Okay, well, welcome everybody, both here in Houston and also online. I know we have a great group of people who RSVP'd to attend here. So we're excited to talk with you about this topic and hopefully put together a great panel for you as well. The question we'll be discussing is the question of voluntary self-reporting to DOJ, specifically in the M&A context. We'll talk about some of the recent policy changes that are in place now. For those of you in Houston here, you do see some articles we've written on this topic. It's been an area of focus for us, this DOJ's focus on the M&A space. And we've written about that. One thing we did not leave, unfortunately, was this 5 things to consider when self-reporting or considering to self-report to DOJ. If you're interested in that as well, please email us afterwards. We'll make sure that gets to you. And I believe that the articles should be provided to everybody who registered and is attending online as well. So my name's Fry Warnick. I'm a partner with Vincent and Elkins in the Washington, D.C., and I co-office in the Dallas offices as well. I'm in the government investigations and white collar defense group. I've been with the firm for almost 5 years now. I focus on really helping companies to avoid trouble on the compliance side. And we handle internal investigations, typically to try to avoid publicity when there's an issue, if something happens internally at a company or halfway around the world. Try to quietly deal with that, fix the problems, make sure that it never leaks out into the press or gets, of course, to the government's attention. If the government is involved, then I deal frequently with DOJ, the SEC, any number of alphabet agencies, and we work with them to make sure we get a fair outcome for our clients. About 90% of what I handle is with companies, and a good deal of what we work on is in connection with transactions and both pre-deal diligence and post-deal integration. And a lot of that is going to be the focus of what we deal with today as it relates to the merger and acquisition space. Before joining V&E, I was a federal prosecutor for 11 years in Washington, D.C., first as an AUSA with the Washington, D.C. U.S. Attorney's Office, and then later with the criminal fraud section, where I focused on FCPA. I was a supervisor of the FCPA unit where we were working on international corruption and money laundering matters.
My name is Brian Howard. I'm a counsel in V&E's Washington, D.C. office, where I focus a lot of my practice on the U.S. Foreign Corrupt Practices Act, and in particular advising the firm's clients on anti-corruption diligence and integration, compliance reviews, and then defending their program investigations and such before the government when things go wrong. And so the topics here today are squarely within what Fry and I do every day, and something we're excited to share with you.
But Craig is a partner with V&E, been with the firm for a number of years now, and his focus is on antitrust. And one of the interesting things about the self-reporting issue that DOJ has been focused on is that for a long time there's been an antitrust leniency program in place. And so one of the items we'll talk about is comparing and contrasting the new policy changes with the antitrust leniency program. Let me turn now to the agenda here that we'll cover today. We're going to flip through here. We'll talk about the evolving steps towards incentivizing self-reports. This is an area that DOJ has really been focused on for some time. The requirements for a declination under the corporate enforcement and voluntary self-disclosure policy, and those have actually changed and evolved over the last several years. We're going to then focus on this new guidance and the incentives that are in place for DOJ's new M&A safe harbor policy. We'll focus also on significant disincentives that do remain and how that should be considered when you're tackling this problem. And then we'll talk about just the key takeaways, where things are now and what companies really need to consider. Craig, hopefully his audio will be back up and running at some point, but then he's going to jump in and talk through the antitrust considerations as well as it relates to the leniency program. And then we are going to have some Q&A internally, a roundtable discussion. Hopefully it'll be a bit informal. Then turn it over to questions from the audience. And as I said earlier, there's going to be polling questions intermixed throughout. So let's go ahead and get started. So this quote here is, it comes from one of the articles in front of you, but one of the hardest questions a company has to face, and in the 5 years or so that I've been back in private practice, this comes up quite frequently. We're dealing with a bit of crisis management issues, and when you find criminal conduct in your company, whether domestically or halfway around the world, what do you do? Do you ultimately self-report that issue to the government or not? In the past 8 years, we've seen just evolving, we'll talk through this in a minute, but a number of evolving guidance that's come out from DOJ as they're continuously trying to calibrate carrots and sticks. On the one hand, the government wants enforcement. They want to enforce the law. They want to deter wrongdoing. They want to make sure that wrongdoers are punished, both at companies and also individually among executives, employees, and otherwise. On the other hand, the government recognizes they can't be everywhere at one place. They do want to encourage self-policing by companies. And so they need to incentivize that, and they would obviously want to be aware.
So you can't hear?
Hold on one second. Craig, I think, can you hear us now? Oh, okay. We maybe take Craig off screen while he's, okay. So as we talk through the various evolving carrots and sticks, one of the, I think there was this misconception by many that DOJ really relies heavily on self-reports as they handle their enforcement. And I'll just say anecdotally, that's just not the case. That when I was in the government, the number of self-reports that came in that we ended up working on were probably no more than 10, 15% of the cases. I think historically, 30 plus years ago, that may have been the case, that on corporate investigations, those were largely driven by self-reports. But one of the issues then, because they've decreased so much, in part because of a just far more robust corporate enforcement generally, the government started focusing on how do we get more companies to self-report, and that was their focus. And ultimately, that leads us to the evolution here over the last several years in how is DOJ trying to calibrate those carrots and sticks and increase self-reports. And so in this modern era, really began in April 2016. Then, kind of the waning days of the last year of the Obama administration, and they came out with a FCPA pilot program. This actually came out while I was supervising in the FCPA unit. And the pilot program was really limited. It was, focused on, potentially reducing penalties and encouraging self-reports, but it was limited just to the FCPA cases. So those were international cases. There was a recognition that those cases were much more difficult to collect and gather evidence. You're dealing with evidence collection worldwide. You're dealing with data privacy issues. You're dealing with a number of, just labor and employment issues that have occurred around the world to make it harder to access employees. And so in light of that, this pilot program occurred. And what ultimately was in place was a program that said, if you self-report, then DOJ will consider, you'll be eligible, and DOJ will consider a declination in these cases. And absent aggravating circumstances, that would be considered. If there were aggravating circumstances, then you could qualify for up to 50% credit off the bottom end of the guidelines, sentencing guidelines, which in FCPA cases, which these days can be hundreds or even over $1 billion in fines, that's not an insignificant credit. The other side of it was if you did not self-report, they still wanted cooperation, and you could still be eligible up to 25% if you still fully remediated and cooperated with the government's investigation. Now, this came out at the time. I believe there was only one individual prosecuted in 2015. The corporate cases had really dipped in the years before, and they really wanted to incentivize more enforcement. But there were significant disincentives associated with it. Number one, those are very modest incentives, and the disincentives were the cooperation. This is in the aftermath of the Yates memo, which Sally Yates, the then Deputy Attorney General, had in place. She was really trying to refocus attention on individual prosecutions as a primary deterrent. And so cooperation meant help the government build cases against individuals. Remediation obviously fixed the problems, but then also disgorge profits. And so even if you got a declination, the government was still going to require you to disgorge any profits you have made, that you may have made back to the government as a result of that. Well, that also can be fairly significant to the tune of 10 or even hundreds of millions of dollars in profits that could have resulted from in the FCPA space, corruption. So that then evolved. That was in place. And in November of 17, then was formalized. And it was formalized into DOJ policy under the new corporate enforcement policy. The the language about just being eligible for consideration of a declination then was more cemented into a presumption. So now you had a presumption of a declination in place, which gave some more comfort. And there was some other language about what qualifies as cooperation. There was some discussion earlier about what you needed to share when you're cooperating with the government about employees, which employees and people that were involved needed to be fully disclosed to the government, et cetera. Again, still though fairly modest in terms of actual incentives in place. And then we flagged here in June 2019, the then Deputy Assistant Attorney General on the Criminal Division, he gave we had a speech, actually, we were on a panel together, and it was the first time we noticed this, that in the M&A context now there was a focus on M&A. And in response to a question about these disincentives, DOJ had in place a policy, if you did receive a declination under the enforcement policy, they would still publish the letter. And so your company, who had fully cooperated and self-reported, would still be known that they had been under investigation. And they didn't get a declination because nothing bad happened. They got a declination because of this policy. Well, as you can imagine, another number of companies don't want to read about themselves in the paper. You're getting a bad news day. And so the question came up, why is this in place? Why do you need to publish? And at this panel, the then Deputy Attorney General, Assistant Attorney General said, well, actually, that's up for negotiation. Doesn't always have to be the case, signaling that actually there had been some cases where companies didn't need to get that letter. They didn't need to be published. And, possibly that it has real world consequences. You may be fending off potential derivative lawsuits, from people who read about wrongdoing, both from counterparties or shareholders, or the like. So that was fairly significant. Also something really not touched on. One of the articles in front of you here talks about actually the impact of this, significance of that. Then the last two areas, on September 22 and January 23 of them, under the new Biden administration here, we've seen, again, attention on self-reporting and in the factors and kind of a rejiggering of what can qualify now for a declination. Brian will speak to this in a moment, but it raised the incentives. Number one, it was no longer applying simply the FCPA unit or the criminal fraud section. Now, this corporate enforcement policy and the voluntary self-reporting would apply DOJ-wide, so across all components for criminal cases. And secondly, the incentives were increased from, if you did not get a declination, you could still get now, instead of 50, up to 75% off of the low end of a guideline range, which actually is a more significant incentive. And then even if you did not self-report but fully cooperated, you would actually qualify for up to 50%. So you can see now even more sweeteners being applied. But as we'll talk through it at some length, significant disincentives still remain. You still need to fully cooperate, help the government bring its cases against individuals. And as it relates outside of the M&A context, those are people that could very well still be in the company, could be senior management, could be directors, could be just employees. And secondly, remediation obviously must still occur. The government wants to be sure that the problems are fixed. And then the profits still need to be disgorged. And not said also, you're still going to be generally public. Any declination will be publicized through a letter. So I'm going to turn it over to Brian now to kind of dig in on some of the nuts and bolts here about the requirements for declinations under this policy.
Thanks, Rye. And we'll focus on the M&A piece in a moment. But before we get to that, the M&A piece of the policy builds on the general self-disclosure program. And so we wanted to walk you through what's expected after you make the self-report, as obviously that's part of the calculation. So in order to get a presumption of a declination under the program, there's a few things that have to be true. The first is that you have to voluntarily self-disclose. And that means that there can't be a pre-existing obligation to disclose. So if you have an obligation, as particular types of companies have reporting obligations, or you have an obligation to inform the government, government contracting sphere, something like that, then you're not eligible. The other piece is that it has to be prior to an imminent threat of disclosure or government investigation. And so if the government knows about the conduct already, or there's already a whistleblower that's in process of telling the government those sorts of things, then you're not eligible. You have to really bring it to them, before they're aware of it. And then you have to do so within a reasonably prompt time after becoming aware of misconduct. And that prong becomes a little tricky because you don't want to report things to the government that it turns out aren't true. And so, you want to do an independent investigation yourself, an internal investigation, to understand that misconduct actually happened before you go to the government. But there's some tension in that because the government wants you to bring the self-report to them before the investigation is complete. And so, when to report is equally a question as whether to report at all. Next slide. Once you've notified the government's aware of the allegation, then you're expected, as Fry said, to fully cooperate. And this has grown over the years what is expected for full cooperation to really apply. You're expected to timely disclose all non-privileged facts relevant to the wrongdoer. And so the government, there was a time where you could do your investigation, report your findings at the end. The government was okay with that for the most part. But now the government really wants you to bring them information along the way so that they can run their investigation in parallel. You also have to be proactive in cooperating instead of just reactive. So it's not just sufficient that you answer the government's questions. The government expects you to be proactively bringing them the information and helping their investigation. They expect voluntary preservation, collection, and disclosure of relevant documents and information, deconflicting witness interviews in the company investigation from the criminal division's investigations. So that means sometimes the government will tell you not to interview particular employees or not to interview employees before the government gets to interview them. Those sorts of things that can be disruptive to your investigation. And then making company officers and employees available for interviews subject to their Fifth Amendment rights. And so, this sometimes means literally flying employees to the U.S. Sometimes employees don't want to come to the U.S. or can't come to the U.S. Sometimes DOJ meets them in London or other places, but the government expects you to facilitate those interviews and to make your officers and employees available. They really expect you, this last piece at the bottom, they really expect you to help the government build its case against yourself and, more importantly, your employees and your officers. And so you can very much be in a circumstance where the company is cooperating and you are actively helping the government build a case where, they're likely to bring criminal charges against your current or former employees in connection with the conduct. Next slide. They also expect timely and appropriate remediation. And so, this means doing a root cause analysis, understanding not only what went wrong, but why it went wrong, what policies allowed it to go wrong, what could you have done to prevent the misconduct in the first place, where were there failings in gatekeepers, finance, accounting, et cetera, that could have stopped misconduct and didn't. They expect an effective compliance program to be implemented. And, they expect you to take a hard look at your compliance program you have and what could be done better in light of the risks that this has identified. Discipline of employees is always a touchy area. The government expects you to discipline employees, and sometimes that means firing employees that you don't necessarily want to fire or taking other actions against them. Lately, that includes trying to claw back compensation when you have the ability to do so, which is a recent touch point of DOJ expecting companies to do that. So, it can be tension against what the company wants, but what the government wants there as well. Retention of business records. And then any additional steps that demonstrate recognition of the misconduct, acceptance, responsibility. And so this, not necessarily public statements outside the company, but there is a focus of late of, making sure that the company does acknowledge internally, that things went wrong and that there was a problem and that the company has fixed it, those sorts of things. Disgorgement, you still owe disgorgement of profit, so you don't walk away without any monetary penalty whatsoever. You still have to disgorge profit. Although in the M&A context, the profit disgorge is typically from the time of acquisition, and so it's not the full scope of the profit, but they expect some disgorgement, forfeiture, and restitution. And then finally, there's the absence of aggravating factors. Next slide. And so there are certain aggravating factors that if they're present in the case, you're not eligible for a presumption. You can still get a declination, which we'll talk about in a moment, but you don't get a presumption of a declination. And so those aggravating factors are if senior management is involved or aware of the misconduct, if the company obtains significant profits in proportion to its profits elsewhere, the egregiousness of the misconduct, the pervasiveness of the misconduct within the company, and whether this is a case where it's a corporate recidivism, whether there's been a prior violation, essentially if there's a certain point at which misconduct is so bad or so high or so pervasive that you no longer get a presumption of a declination. Next slide. Now you can still, as I said, get a declination. It's just not a presumption. And so if there are aggravating factors present, DOJ may in its discretion decline if all of the following are present. The self-disclosure has to have been made immediately upon the company becoming aware of the misconduct. Again, tension of you want to investigate to confirm there was actually misconduct, and is that immediately, right? And that's a point for negotiation at times with the government. At the time of the misconduct, the company had to have had an effective compliance program and a system of internal accounting controls that enabled the identification of misconduct and led to the disclosure. And so what that means is you can't adopt a compliance program after the misconduct and qualify. You have to have had a compliance program already in place. And then the company provided extraordinary cooperation with DOJ's investigation. So we already described what full cooperation means. What extraordinary cooperation means is a bit open. But the government expects you to go above and beyond. If it's their aggravating factors, it was pervasive misconduct. If you want a declination, you're going to have gone very far in your cooperation with DOJ. Next slide. So what do you get if there is a resolution? Either because the presumption would apply, but there's such conduct that that they're not going to get the declination, the presumption doesn't apply. What do you get? Under the new program as it's currently drafted, the criminal division will recommend a discount of at least 50% and up to 75% off the low end of the sentencing guidelines. For recidivists, prosecutors have discretion. So you still get the discount, but they have discretion as to where the starting point is, where that discount applies. It's no longer at the low end. Corporate guilty pleas will generally not be required, absent particularly egregious or multiple aggravating circumstances. And then the DOJ will typically not require the appointment of a monitor if the company has implemented and tested an effective compliance program and remediated the root cause of the misconduct prior to the resolution. So again, this is the root cause analysis and understanding what happened and fixing it. You have to demonstrate that in order to proceed. Next slide. Where you don't self-report, but you later cooperate, right? So either you've done your investigation and you waited too long to self-report, or the company decided not to self-report and later the government found out about it. You can still get some credit by cooperating, just not the full presumption of a declination. In those cases, the criminal division will recommend a discount of up to 50% off the low end of the sentencing guidelines. And for recidivists, prosecutors have discretion to determine the starting point again. Corporate guilty pleas may be required, and DOJ may require the appointment of a monitor, right? So if you don't self-disclose, but you end up cooperating, what the difference is that the company may have to plead guilty. A monitor may be imposed, which can itself cost millions of dollars per year, depending on the scope of the monitor. It can be very disruptive. And then you get less of a discount off the sentencing guidelines. Next slide.
So thanks, Brian. This is now our first polling question here, and just show of hands here, and also please click online. Remember, we'll need you to do this to qualify for CLA credit here. But outside the M&A context specifically, just based on these recent changes to the corporate enforcement program and the self-reporting credit that will be available, do you believe these credits materially change whether your company would self-report to DOJ? I have at least one in-house counsel here. And it is looking, I think we still have some numbers coming in. So internally here, it was unanimous, as a no, but that's actually not surprising. I think I tend to agree with you. And then looks like about 60-40 yes, that there was some online at least, that this did materially change whether people would self-report. Thank you all for sharing that with us. So I want to now turn our attention to the safe harbor policy, the M&A safe harbor policy that's now in place. This is a quote from the current Deputy Attorney General, Lisa Monaco, and what she was saying here when she announced this new policy. A couple of things to focus on. They want to encourage companies that are trying to do the right thing to self-report. And secondly, they want to identify and prosecute individuals. Again, recognizing the deterrent factor of individual prosecutors really being primary, having primacy over necessarily just over getting fines for companies. So this new policy, interesting kind of note is it has not been reduced to writing yet. This came out in a speech on October 4th from the Deputy Attorney General. And it leads some questions as to whether or not there may be some additional tweaks. But this is being treated very much as DOJ policy now for the past 4 months since the speech was made. And the first significant thing here is that it's setting forth these clear timelines for self-reporting and for remediation. Now, I will say, just having worked in the space for a while, there's a general practice beforehand that people tried to operate under for 6 months. That in the post-closing context of an acquisition, that you have about 6 months to just determine whether or not you have identified any criminal wrongdoing and to self-report and get credit for that being timely. Here now, DOJ is really cementing that as a firm guideline that the self-reporting must occur within 6 months. And that's not actually a ton of time. And then secondly, that remediation, in order to qualify for the declination, that remediation is going to occur fully within 1 year of closing. And again, that is not always a great deal of time. So, but what they're basically saying is we're lighting a fire. You companies in the M&A context, you want to avail yourself of these benefits. Here are the guidelines you need to be operating under. A couple of significant items here. The aggravating factors that Brian was just speaking about as to when that would apply to rebut the presumption and that DOJ would still seek an enforcement action. If those types of aggravating factors existed at the acquired company, high-level management was involved, it was pervasive throughout the company, or the issue had to, maybe it resulted in really significant profits, that's not going to be a factor. You can still get credit. And then secondly, the company is, if there was a prior enforcement action, if the company would be deemed a recidivist under DOJ's general approach to recidivism, that will not be a factor. And that's actually fairly significant. This administration particularly has had a focus, at least rhetorically, on increasing punishment for recidivist companies. And so they make it clear that's not going to be a factor in the M&A context. And they're very clearly, the government's very clearly now setting this expectation that you can qualify for a declination. You will get that declination if you report within these timeframes and do what's required. The limitations here. So while we talk about the 6 months and 1 year, there is of course, a caveat. We're lawyers, and there's a reasonableness analysis here. There's a recognition that deals will differ and all transactions are not the same. So you can still make the case if you come in 9 months later, even a year later, you can still make that case that under the circumstances, we didn't self-report. How is that case made? Well, you need to report a crime. It's not always clear that what you're discovering is a crime. And so I think there's definitely a recognition among practitioners that a real investigation has to identify not just did wrongdoing occur, but did it rise to the level of criminal conduct that should be self-reported. DOJ also, in the national security context, there's an explicit limitation. Clearly, they don't want, when we're dealing with national security issues, that 6 months is going to be condensed. If you identify something that really could put lives at risk, then they do not want people sitting on their hands waiting to do something. And so be very mindful of that if you're in the defense contracting space or if you're otherwise dealing with national security issues. The timelines there may actually be condensed. The due diligence piece of this, I know we'll talk about as well, is very important. And when you're going through an M&A deal, you have pre-deal diligence and then you have the post-deal diligence and acquisition timeframe. What they're making clear is you need to be doing pre-deal diligence, making sure you identify what you can before any closing occurs, recognizing that there are always limitations on the kind of information you can receive before a closing occurs. But then afterwards, you need to really fully integrate and conduct robust diligence if you don't want to be subject to potential successor liability as the acquiring company. And DOJ is also not going to do this for companies that otherwise were going to be required to self-report anyway. And you do see this sometimes in certain types of defense contracting, government contracts require self-reports as part of it. Companies that are already under, let's say, a deferred prosecution agreement or otherwise under DOJ supervision may have separate obligations, and they very well may not be able to receive the benefits of the new policy. And now I just want to talk a bit about the significant incentives that still remain. And we talked about it already now several times, but the, number one, the cooperation that Brian was just talking through. The government really is expecting companies to bring cases and help them bring cases against individuals. Now, in the M&A space, though, this is a little different because what you're going to be self-reporting, though, is not necessarily individuals, executives, right, that you have any longstanding relationship with. These are people that were at the old acquired company. Sometimes could very well be people that were not entirely honest about all the information in the pre-diligence phase. So that particular disincentive is probably mitigated somewhat. It's definitely mitigated in the M&A context. But it still remains. Obviously, you still must cooperate. In the course of that cooperation, there is the potential for waivers occurring in connection with attorney-client, works product privileges, and so that's something you definitely need to be mindful of. I think a real significant disincentive is, and I've seen this play out when I was in the government, company would self-report, expect to have a declination hopefully within a year or two. And, I just recently read about a resolution that resolved in a declination, but it was 6 years later. And truly, 6 years for the government to investigate a case, and that's just the voluminous document requests, the witness interviews that the company is still going to be required to facilitate. Oftentimes in the international context, that's witness interviews, that's negotiating exceptions to labor agreements and employment agreements with people to make them avail themselves voluntarily to interviews that otherwise local laws may restrict. When you're dealing with foreign documents, that can be translations of documents that are incredibly expensive, that can involve, navigating thorny data privacy laws. So there's a number of things that occur here that even when you self-report, you're not just self-reporting and saying, I'm done, go after it, DOJ. They're requiring you to cooperate, and that cooperation really can be expensive, even when it's something you brought to the government's attention. It's something you really can't disregard. And then on the disgorgement of profits, and I want to talk about that and the publicity side of things, because I actually think what there is, what people aren't really talking about, is an opportunity here. The disgorgement of profits, while still technically required, is really different in an M&A deal. In a normal, let's say, FCPA case, the profits, if you bribed your way into a new market, well, those profits could theoretically be all the profits you made from the beginning of the time you've been doing business in that market. But in the M&A situation, you're self-reporting as an acquiring company that if you did so, let's say, within 6 months, what are the profits that you have actually accumulated in that 6-month period? It very well could be de minimis, or it could be fairly insignificant. There's an opportunity here, I think, that with advanced advocacy, anonymizing who you represent, but going to the government saying, we want to take advantage of this policy, but we want to be very clear, we should not have to pay a dime. We just got this company, we haven't really benefited from this, and it wouldn't be fair to us to have to be penalized in a way to disgorge profits from the predecessor entity. This, of course, reinforces the need for good reps and warranties to cover yourself in that process as well. But outside of that, there's just good policy arguments to be made here to take advantage of on this particular issue. And then secondarily, we touched on it earlier. There really is no good need, if you're going through the process of self-reporting, that DOJ should require you to receive a letter and that they make that letter public and give you that type of bad news day that you've done everything right. Really, we want to decline, but you don't need to put it up on your website. And if you go on DOJ's website today, you can see all the letters that they've published and all the companies that have been really publicly shamed, even though they did everything to receive a declination. So I do think in the M&A context, there really does present a unique opportunity here for companies to avail themselves that really wasn't available otherwise, notwithstanding some of the other disincentives that are still there. So just what does this mean for you? What are basically the takeaways here? Look, there are now significant new incentives. We've seen this rejiggering of the percentages that people can qualify for just generally under the enforcement policy. That companies now are more likely to get declinations, even if there is aggravating circumstances. Generally, the percentages of deductions off of the penalties can be significant. But now also in the M&A deal, M&A side, there's very significant advantages that government's trying to propose to really consider self-reporting. The uniformity is important. You really want to make sure that similarly situated companies are being treated similarly, that if you self-report to the U.S. Attorney's Office in the Southern District of New York, you're not going to be treated differently than if you're in the Southern District of Texas. So this policy now applies nationwide. It does apply also outside just the criminal division. It's applying to any criminal case in DOJ. So that could be national security cases, that could be environmental cases, that could be, obviously fraud, accounting fraud, well more than just the old FCPA cases that had been the focus years ago. I think a big piece of this is the due diligence side. If there's one thing to take away, DOJ has really been pushing compliance on companies over the last several years. Now on the transactional side, DOJ is basically saying, do your due diligence, really know what you're buying ahead of time, and then afterwards, you've got a robust, aggressive timeline and a schedule to meet to figure out if there's a problem and to fix that problem, and if you want any credit for it, to make us aware of that problem. And that's an area that Brian and I and Craig focus on intensely in connection with the transactional assistance we provide on those deals, both pre and post closing. And then, as I said earlier, this is still just coming out of a speech in October. So this has not yet been reduced to writing. And maybe someone from DOJ is on the line right now and wants to take some of these ideas and incorporate some final ways to remove disincentives. But the goal would be, hopefully this comes out in writing, there'll be a little bit more clarity. But it is very much policy as we stand here today, even though it's not in writing outside of the text of a speech. And then, as I said at the last point, if you do want to avail yourself of this, it is really critical, if you want to take advantage of some of these opportunities, that you reach out in advance and try to get that clarity from the government before you walk in the door with a company. Obviously, that means outside counsel getting involved, anonymizing who they represent, but reaching out to the right people internally to try to get some soft commitments on what would occur if a company were to walk in the door. Let me switch now to our second polling question. So now in the M&A context, with these recent policy changes, would the DOJ's recent policy changes influence the extent of diligence your company conducts before or after closing? So the question is focused on the diligence and or your company's post-acquisition integration efforts, so the post-deal diligence and integration. So I'll ask internally here. So one, both diligence and integration, diligence only? Okay. So I'll give a few seconds here for the questions to come in. Okay. So it looks like that's what we're hearing here is reflected as well online about majority of folks saying, yes, it will enhance this guidance does materially influence the types of due diligence that would occur pre and post deal. A handful of people saying no, yes, just to diligence, yes, just to integration. And then about less than a third says, no, this doesn't really materially affect that. Okay. I'm going to turn it over to Craig. I think your mic is worked out now. And Craig, go ahead also maybe just quickly introduce yourself as well. I tried to do you justice, but nobody can. And then, okay.
Well, thank you, Fry. Sorry for my technical problems earlier, but I think I'm back and hopefully you can all hear me. I'm Craig Sebald. I'm a partner in the Washington, D.C. office. My specialty is antitrust litigation and defending companies in antitrust criminal investigations. So it's a pleasure to be with all of you. I was actually just gratified by those results because I do think there's further due diligence and is really important, and we can get into that why it's on the antitrust side, but it's, I think, important across the board. I thought I would give you a little overview of the antitrust division's leniency program. In Washington, everything tends to be a little more complicated. The antitrust division really has gone its own separate way in terms of self-reporting policies. It has its leniency program, and I think it was one of the first. I think it was the first division to have a self-reporting policy. It really goes back the whole span of my career. So 30 years ago is when it came out, and it's a pretty robust policy in that it protects companies and in many instances corporate employees from prosecution if they self-report antitrust crimes in a prompt manner. There's some unique parts of this. You have to be first in. You have to be first. There is no coming into second place. If you're second in, you don't get any protections. So you have to be the first company in. Not surprisingly, you have to confess all your sins in whole. Another criteria is that you can't be the leader or organizer. I'll just say that I'm not sure that that is as adhered to as other parts of this, because we've seen in some situations where a leader or an organizer did get amnesty. So you shouldn't be dissuaded if you really are the leader, organization, or organizer for going in. You have to give full cooperation. It's very similar to the things that Fry and Brian were talking about. Interviews, proffers, documents. You get to spend a lot of time at the DOJ producing documents and having witnesses talking to them. They're pretty respectful of the privilege. They're not going to pressure companies to waive the privilege as part of the cooperation. So that's a good thing. Another thing you have to keep in mind is to get leniency is you have to make restitution. But again, that's not as a forceful requirement, because, as you know, in antitrust cases, you have civil suits many times, almost all the time. And the DOJ takes the view that if you are involved in civil litigation, especially by your customers, that checks the box for making restitution. And then importantly, it also applies not just to the underlying antitrust crimes, but with crimes associated with price fixing, things such as wire fraud and obstruction. We see that a lot in antitrust investigations. But it doesn't bind you to other divisions. So if a company is, for instance, also engaging in FCPA violations, they're not going to get protected under leniency. Just the antitrust and other associated crimes with the antitrust. Just another for overview, there's really two types of leniency. We have type A, which is where a company is bringing something completely new to the attention of the DOJ. When you do that, you get full protection for the company and the employees and officers. So that's kind of the golden part of the leniency. And then there's type B. So you can even get leniency where the DOJ knows something about what was going on in the industry, but lacks what they call evidence likely to result in a conviction. And they'll fairly readily grant type B leniency in many circumstances. The one big difference is that while the company gets protected, the protection of employees is discretionary. With that being said, one of the things we've seen in the last few years in the antitrust bar is that because of the burdens, not only with the Justice Department, but now we're seeing many countries also have most first world, second world countries have their own form of leniency. So, no one not really operates just in the U.S. anymore. So if you have to apply for leniency in the United States, you're likely applying for leniency in multiple jurisdictions, and that has a lot of burdens. And people think that's a disincentive for applying for leniency. Why don't we go to the next slide? We just don't really have any guidance, truthfully, from the antitrust division, how they're going to harmonize the policy, their leniency policy, with the new M&A safe harbor policy. As Fry said, this policy, the new policy, is supposed to apply to all the divisions at the Justice Department, so it should apply to the antitrust division as well. I guess when I kind of look at the two, if you had a choice between the M&A safe harbor policy or the leniency policy, it strikes me that the leniency policy is a much better deal if you want to self-report. And I say that for a few reasons. One is no timelines. Fry and Brian talked about the pretty strict timelines under there. You have to be first in, but once you're first in, you get to cooperate with the Justice Department in a mutually agreeable but prompt timeline. Importantly, there's no public disclosure. It's if there's a lot of cases where a company goes in and gets leniency, and the DOJ, for whatever reason, decides not to bring a case. No one will ever know that you went in and got leniency, and that's important. Another, I think, important factor is you get the protection of individuals. And then finally, I think it's an arguably lower standard on restitution than what Fry and Brian were saying. So that's kind of an overview of the antitrust leniency policy and how I think it compares and contrasts with the M&A safe harbor policy. And like I said, at some point, we're going to get some guidance from the antitrust division how they're going to meld these two policies together. With that, I know, Fry, and Brian, we've got about 10 minutes, and I thought maybe we could pivot to some roundtable discussion. And so I have a question for Fry, and I just encourage the audience. We have some questions that we're going to bat around ourselves, but if you have questions, I encourage you to submit those. We'd rather answer your questions than our questions. But let me just kick it off, Fry. You've had a distinguished career at the government. You spent 11 years as a federal prosecutor, and your last position was supervising the criminal division's FCPA unit. I'm just really curious, we talk about these rules a lot of time theoretically, but this is really a practical question. I mean, really, do people are actually taking advantage of this, and how often are you seeing companies self-report cases, especially from your time there and, now that you're in private practice?
No, it's the self-reporting question is what we began with, is this kind of thorny issue. I will say it was not as prevalent as I expected it to be when I joined the criminal fraud section. I also was under this concept that self-reports were really prevalent. I think I gave the number earlier. By the time I left, I think it only accounted for maybe 10 to 15% of the cases that DOJ was working on. DOJ had, by the time in the time I was there, I joined in 2014 from the U.S. Attorney's Office, and there were 19 federal prosecutors focusing on FCPA cases. By the time I had left, that had been grown to 35. Now there are over 40. When I joined, there were 0 FBI units focused on anti-corruption, and by the time I left, there had been 4 dedicated FBI international corruption units in Miami, LA, New York, and DC, really focused on kind of splitting the world between them and trying to build these cases. So there was a lot of more of the standard kind of gumshoe type of work that led to cases, journalists, investigative journalism, creating leads, whistleblowers, and the like. So self-reports were not as prevalent, which I think explains why this focus has occurred. And I mentioned the FCPA unit only because, for a long time now, it had been one of the primary criminal enforcement components at DOJ was on this particular law. Rightly or wrongly, that had been the case, and so that had been where a lot of the focus from DOJ was. But so the answer, I think, is this calibration certainly seems to be a result of the ongoing issues they've had with encouraging more and more self-reports, to the point where we see the recent incentives being increased kind of year after year.
All right, thank you, Fry. Brian, I got a question for you. You've at V&E, you've been our key person in terms of helping companies develop compliance policies and putting them into place. But you also spend a lot of time on deals and advising on transactional risk, especially when it comes to anti-corruption type issues in countries and in companies operating in markets throughout the world. I'm just wondering how that background kind of factors into your thinking when discussing potential self-reporting and cooperation with DOJ when you're talking with your clients.
No, that's a great question, Craig, and it's very important. I think we can all agree compliance is important generally, and compliance programs are important. But what the new policy, really makes clear is, and to a degree, the older versions of this policy, is that you have to do timely and efficient pre-deal diligence and post-deal diligence and integration. And as the acquirer's compliance program drives that requirement in a lot of ways. And so sophisticated companies that have well-developed compliance programs, their compliance program to ensure that it's being done. Whereas sometimes we see it in other cases where that's not done, and it's a little bit later when somebody recognizes it should be done. Also, practically, whether you're in the M&A context or not, when you go to DOJ, as I said earlier when we were going through the slides, you have to show that you've remediated the issues and that you have an effective compliance program that has been changed to prevent whatever the problem was. And so what compliance looks like and how you're going to present that and phrase that to DOJ if and when you self-report sets very much the tone of the conversation you're going to have with DOJ, right? Are we a very sophisticated company with a well-developed compliance program and there's this one thing that we just couldn't have prevented? Or is this a company that didn't have great compliance controls and they've, since becoming aware of that, they've moved aggressively to implement compliance controls, et cetera. The further along that path you can be when you initially talk to DOJ, it can really set the tone for the cooperation and the ultimate resolution. And so I think it's a very important component of that.
Hey, Brian, I see we've got a question from one of our folks listening in today, and I think it's right up your alley. What have you been seeing in terms of, and Fry, obviously, jump into, what have you been seeing in terms of negotiated reps and warranties being modified these days to avail this new self-reporting regime? Have you seen much difference in the reps in the last 6 months and what clients are thinking about?
Yeah, it's another good question. So I think for general reps, it hasn't changed all that much, right? The comprehensive reps that at least that we would put into deals we worked on already really addressed compliance risk and for at least moderate or high risk deals, often indemnification provisions, those sorts of things. I think where I have seen the biggest difference is when there's a transaction where you identify a potential concern during the diligence, but the deal progresses forward. Right. And so the client's corporate team decides they're going to move forward in light of this red flag and they're going to put more fulsome indemnification provisions, those sorts of things in. I think that's really where it changes the conversation for the reps in the agreement, because you're looking at cooperation and audit rights and that they're going to provide you, you don't always get the books and records that you would want in acquisition that would show the misconduct. And so maybe you negotiate to have access to those. You require a joint self-report potentially where you and the seller go into DOJ at the same time and report the misconduct. Those sorts of things, there's a lot more room around the conversation of the reps when you've actually identified a red flag. But absent a red flag, I don't think it's actually changed much as far as the warranties themselves.
Yeah, interesting.
And
Thank you. Go ahead,
Let me
Brian.
jump in real quick, just because I see we have about 5 minutes left. I want to make sure we get the last polling question in, and then I think we have at least one other question here we'll raise from the audience, and we can speak a little bit more in the roundtable. But just before we forget, so on question 3 here, the last polling question, on balance, do you believe the changes make it more or less likely your company would self-report violations discovered post-closing to DOJ? Give it a few seconds here. Okay, so at least online, the numbers are pretty significant. About 3/4 people saying yes, it actually makes it more likely, and same here in the group here. So I think DOJ would be very pleased to see that result, saying that they're actually, at least theoretically, that was beneficial. I'll move back just real quick. I know one other question we received and was, does the new policy, this M&A safe harbor policy, reflect a change, or is it just an adoption of best practices? In many ways, it is reflecting those best practices that are in place, but I think what we see is DOJ saying they're going to reward those best practices. They're cementing some of the timelines, and in my opinion, what they're saying is, we know this is out there, what companies are trying to do, and now you can hold us to our word that we will actually get you a declination if you adopt those best practices, follow these timelines, and also do everything that we're asking to receive the benefits of the safe harbor policy. Brian, I don't know what you think.
No, I think that's right. I think it memorializes what a lot of companies were doing, although I think that even companies that were doing those best practices in a lot of deals weren't necessarily doing them in all deals, right? There are deals that close too quickly to really do pre-due diligence, or where you don't have access to the books and records, or where you're purchasing a line of a business and not the whole business, and so it makes things more complicated. You're not getting the employees with it, those sorts of things. And so I think it adopted the best practices that apply generally, but I think we all know that in certain deals, it's hard to apply those best practices. And I think that's a little bit where there can be some art as to what you're going to do now and whether you're going to do anything different because of the policy.
Craig, let me,
Go ahead.
well, I was going to ask you,
Do you want
Craig.
to give should we give a few seconds of close up, as we only have 2 minutes left? Let me kick it off, and I'll turn it over to you guys. I would say that, from the antitrust perspective, this issue of buying companies that then have antitrust problems, I would just emphasize is a real problem. I've advised a number of. It's shocking how many clients I've had in the last 10 years where they were antitrust compliant but did an acquisition, and what do you know? A couple of years later, the Justice Department issues a grand jury subpoena, and you're in the midst of this investigation. A lot of times, the employees are gone because they left at the merger, and so I just wanted to emphasize that I really do think it's a real problem, and it's something that we're seeing time over and over again. And it's a tough situation when you buy an antitrust problem, and it really, I think, does highlight. And we're seeing even before this policy, we came out with some guidance to say, look, doing due diligence from an antitrust perspective is really important. And I think people normally think about due diligence on environmental issues and foreign corrupt practices issues, but we're really encouraging people to think about the antitrust as well. So I just want to emphasize as a closing remark that I do view this as there is a real problem here. Maybe the policy is not perfect, but I think the takeaway of doing due diligence is really important.
No, I'm glad you mentioned that. And I think, from my perspective, Brian and I are handling so much of it's almost second nature now, especially if there's any international touch points, that you have a anti-corruption or a sanctions component to the diligence process. But I think, Craig, to your point, antitrust is equally important and needs to be part of that suite of, compliance work that's being done on the diligence side. So I'm glad you did mention that. And, sometimes that means educating the deal team, internally at the firm a bit, but also can mean educating the deal team in-house at the companies as well. So really important point. I think we have covered the questions that have come in that we've seen. I don't know if you have any questions here. Otherwise, really appreciate everyone being here today. We will have the articles we've written on this available to everybody. And as I mentioned earlier, 5 things to consider when deciding whether to self-report is a kind of quick one-pager. If you would like to receive that, just email Craig or me or Brian. Emails here below, and more than happy to help. But thank you all for attending.
Thank you.
Thanks all.